Okay, welcome everybody, and thanks for showing up. It's really wonderful to have the opportunity to welcome Talha Syed here. Many of you may have seen his theory workshop yesterday, but if not, you're in for a treat. Talha is a superb scholar and teacher and friend, and he's going to be talking to us about the law and political economy of torts today. So he's going to speak for around half an hour, and then we'll have Q&A. And obviously call on people in the room, but also if people online want to put a question in the chat, I'll try to insert your question right in the Q&A function. I will try to insert your question in the discussion as it follows. So no further ado, Talha Syed.
All right. Well, thanks so much, Amy and Corinne and Sarah, for having me do this. And I'm happy to just sort of, I guess, dive in. As I understand it, the law and political economy of torts raises, you could say, two topics. One, what is law and political economy? What's LPE? Second, how is it relevant to torts? But of course, buried in that is the third topic. What exactly is torts? And so what I'd like to do is begin with that, oddly enough, because often LPE is done in a kind of outside-in approach. We care about questions of power and distribution in general, and then we ask what those mean in these specific fields of law. And I think that's a totally valid way to go about it. But I want to suggest another way to do LPE as well, which is inside out, starting from within fields of law, and then branching out into larger questions of power and distribution and so forth. So in a way, I want to talk about the L in LPE, and then later talk about the PE and LPE and how I understand them to be related. So the first and basic question is, so what is torts about? And I think simply to even ask this question is already to form a bridge between LPE and tort law, because the question, what is torts about, is almost never asked of any basic course. I know Yale's on a 1L course, but you all take torts at some point. No 1L course, in my experience, do the people ask, well, what is this field about? Instead, you just sort of dive into a bunch of doctrines and a bunch of policy discussions, and it's not really clear what aspect of society we're particularly talking about. And that is the way a lot of legal fields are taught. And it's a way which induces a kind of internalism about law. And what I want to say is, well, no, I don't think it makes sense to try to think about or study tort law until you have some working idea of what it is you're studying. What is it about? And so that's what I want to start with. What is tort law about as a field of law, and how that field of law then branches out into larger questions of power, distribution, etc. And how thinking about law in this way, using the anchor of tort law, maybe tells us something about how to think about political economy as well, and sort of linking up the L and the PE together using a similar kind of method. So what is torts about? So first, what is law about? And so law in modern societies, I think, is fundamentally about social relations, which are structured in a particular way as rights. And by rights, I don't mean some normative argument about rights. I just mean the institutional relation that is a right. And so that's the fundamental point. Rights are an institutional or social relation, right? Rights are not an individual attribute. They're not something you have, like eyesight for some, or some needs you have, like hunger. Okay, rights don't exist in the absence of other people. There are no rights on a desert island. Rights just are social relations. That's just what they are. And so it's this kind of reified view that many people have rights as sort of things or individual attributes or something. The fundamental point to understand is no. Law is dealing with rights, and rights are social relations. And what's particular about the structure of rights, which is different than other social relations, is that they're inherently competing or conflictual. If you have an entitlement, someone else necessarily has a disentitlement. If you have the right to do something, someone else has no right to stop you from doing it. If you have the right to stop them, then they have no right to do it, and so on. So all of law deals with the structuring of social relations via rights, and rights are simply social relations, and they structure the social relation in a particular competing interest way. In every rights argument, there's some competing pairs of interest that the law has to adjudicate and dispose of. That's the whole ballgame. And so that's just law. So what is tort law about? Well, each field of law is basically distinguished by disposing of social relations via rights with respect to different subject matters. And you can discuss and debate what the subject matter is, but having some tentative idea of a subject matter helps organize your thinking. And so tort law's subject matter, I think, fundamentally comes in two buckets. The main area of tort law that everyone studies is the law of accidents. Negligence, strict liability, so forth. Well, what is that all about? It's about one thing, risk. Right? So tort law in that way is just the law of risk. The emergence of risk as a systematic social phenomenon is a modern phenomenon, starting in, roughly speaking, the 17th, 18th century, and then expanding and exploding in the 19th and 20th century. The idea of omnipresent, interdependent risk from all sorts of activities that are otherwise beneficial or productive, but carry with them the potential downside of someone being hurt or something bad happening in some probability, is a peculiarly modern phenomenon as a fundamental feature of social life. And that's the area of the law of accidents, disposing of social relations with respect to risks. Then there's another area, intentional torts and so on, which deals fundamentally with how we balance in our society competing interests that persons have in their integrity versus their liberty, their security versus their liberty, the classic, John Stuart Mill point, security, liberty. That fundamental tension is the heart of this other area of law that we call the law of civil wrongs. So tort law has these two features, areas, law of accidents, law of civil wrongs. So now I want to step back and to sort of make the fundamental point, which is that law being about social relations must always be understood in a historical context, because social relations are historically changing. It's just not credible as an intellectual enterprise to understand law in any area outside of a historical context of whence it came, where it is, where it might be going. All law is historically situated or historically specific because it's about social relations, and social relations necessarily will be changing, shifting, transforming over time. So you've got to root every area of law in some understanding of its historical context. And so before I get into the historical context or phases and development of the law of accidents or risks and the law of civil wrongs or security versus liberty, I want to sort of suggest that this basic elemental framing of social relations that are historically variable is a fundamental rejection of the two dominant modes of thinking about tort law that prevail in at least self-reflective theoretical legal scholarship in American tort discourse, which are to understand these areas as either about corrective justice or social policy. So the corrective justice view is the idea that tort law is about transactional equity between two private individuals, one of whom has wronged the other or not. And the point is to correct the wrong by restoring to some status quo ante baseline. And that's a dominant frame of understanding tort law until around 1960. And it continued to be the dominant frame, not in theory, but in practice, maybe even later. Well, actually, I'll get into the dates later. But what happened in the 60s was this guy called Ronald Coase, who came along and said, well, look, everything you're saying as a matter of the plaintiff should win against the defendant because the plaintiff has physically invaded the defendant's area or physically harmed or caused them is a misconception, because in fact, what you're causing a unilateral transaction is a bilateral or joint causation transaction. Both parties can be understood to be parties to the problem, because if the plaintiff just relocated upstream, they wouldn't have the problem of the defendant's pollution. And in any case, shutting down the defendant's activity is itself a social cost. And this basic reframing of Coase made unavailable all the corrective justice moves. And by that little move, changed the subject matter of tort law from private corrective justice to a question of social policy. Now, when Coase does that, he then immediately, and so when Coase did this with social policy, this is just a reworking of an earlier insight by the American legal realist, fundamentally Wesley Hopel, who put the fundamental point that law is rights and rights are social relations on the table, but that hadn't absorbed fully. So Coase had just basically reinvented the Hopelian move, but his main contribution was not that. His main contribution was then to defang the Hopelian move of any critical bite by translating the social relational questions of risk into questions of social policy, which are to be analyzed as failed market transactions. And when you analyze it that way, you reduce the question of social relations to the question of bilateral market transactions, potential or actual. And when you do that, you necessarily, conceptually, reduce the social policy question to a question of market metrics, of which the main one is efficiency. And so, since 1981 and the Reagan White House, every executive, every president has signed an executive order making cost-benefit analysis in the economic efficiency mode the dominant yardstick or metric for evaluating regulation by the administrative state, right? And so I'm going to put all this in a historical context in a minute, but the point is to show just the sheer power of what Coase did. It's the fundamental neoliberal revolution in law is Ronald Coase. He did the theory in 60, but it only really took by the late 70s and became policy from 80 on. And this includes every White House administration, okay? Obama, Clinton, as much as the others. So it's the general uniform default consensus view that you handle questions of risk, which are about interdependent social activities via the analysis of potential or actual market transactions. And so what you do is you take the question of social policy and make it about, social policy. So now we have two frames, corrective justice and social policy, understood as economic analysis. And the fundamental shift that we have to do, I think, in the LPE of Torts is to drop the corrective from justice and to drop the policy from social. And tort law is about social justice. Social justice is the question of the distribution of the burdens and benefits from joint interdependent social life, social relations. And so in the area of risk, it's about what are socially acceptable levels of risk. When levels of risk get materialized, who should bear what cost? What should be the distribution of the burdens and benefits across the different parties who can be understood to be part of this activity? And understanding those questions as social justice questions is a fundamental move away from the social policy approach. Because if you adopt the Coasean economic social policy approach, you inevitably reduce the social question to a question of private individual calculation. Because anytime you attempt to model the question of fair risk analysis on the model of economics, your only approach, and this is from the 1940s on, the Rand Corporation developed this. Elizabeth Hoffman has a whole book on the history of how this formed in the 40s and 50s. Economic analysis with its roots in the Rand Corporation, thinking about how to do analysis of risk at wartime. And they basically came to the fundamental idea that what you have to do is you have to ask how much each individual would value various possible risks and various possible costs and benefits, and then trade them off internal to themselves. Now, I can't get into the technical stuff, although I will in question and answer if anyone wants. But that way of thinking, which then John Rawls took over with the Veil of Ignorance, Richard Posner took over, Kaplow and Chavinsky, Kaplow and Chevelle took over, Ronald Dworkin took over, everyone took this method over, necessarily leads you either to one determinate answer, the efficient outcome, or to no answer at all. Why? Because it forces the analysis to trade off benefits and costs of potential risks and schedules of costs internal to one person's life. But if one person internal to their life has to trade off various risks, they will, as a matter of rationality, maximize benefits net of costs, or you'll say, who knows what they'll do in determining. But what is fair across human lives is not the same as what is rational internal to human life. Each of us may or may not be more or less prudential in valuing and maximizing whatever we think we want to value and maximize. But the point fundamentally is that what is fair across lives simply can't be modeled on this internal to a person model. And all economic analysis involves this fundamental reduction. All economic analysis within the mainstream involves the reduction of questions of social fairness to questions of individual prudence, which are then aggregated across people. I can't get into the technical parts again, as I said, but that's the fundamental move by which COS and economics drains the questions of social justice out of tort law by translating the critique of corrective justice or private transactional equity and status quo baseline thinking into an economic way of thinking. So those are the two dominant modes. One is a pre-social approach of corrective justice, where there's some naturalized baseline which must be restored without asking whether that baseline made sense or what the wider effects between the two parties' conduct is, and so on and so forth. Corrective justice, or accepting that it's a social question, but then making it a question of policy reducible to a question of economic analysis. So the third approach, again, the social justice approach, puts front and center the question of what are social judgments of acceptable risk levels and what are social judgments of the fair distribution of burdens and benefits. These are inherently normative value political questions, and they can't be understood on the model of individual rational choice, even if you accept all the premises of individual rational choice as acceptable. It just doesn't matter. It's not about arguing about that the premises aren't right. It's just that that model drains the whole question of its fundamental political significance. And so that's in the area of risk. I'll say a bit more about the other area of liberty and security, but I want to sort of make my further point, which is once you understand that these areas, social relations regarding risks, social relations regarding liberty and security, are social relations, you have to understand them in their historical context. And it's not plausible to understand American tort law outside of understanding what's happened over the last century in American tort law in terms of three major waves of law. And these three major waves of law, the periodization and the content I'm going to give, I claim are common to tort law, antitrust law, intellectual property law, all sorts of areas of law. They've all gone through these three phases. Constitutional law has gone through these phases with an exactitude, right? From 1870 to the 1930s was a phase of classical liberalism. From the 1930s to the 1970s was a phase of welfarist liberalism, or the New Deal. And from the 1970s to the 2016 election was a phase of neoliberalism, right? And we all now understand that we are in a period of architectonic place-shifting change. No one knows what the fundamental new realignment is going to bring, but we're all in a period of ferment. The stakes are very high. There's going to be a new institutional ideological settlement in this country. At some point, it's going to congeal, and it's going to provide a discursive or ideological framework and an institutional or structural framework for many decades hence. That if history teaches us anything, right? American history has the periodization. There's an earlier periodization, of course, before the Civil War, but the Civil War interregnum not being periodizable. But in any case, these three periods have distinctive ideological and institutional defaults. In the 1870s to the 1930s, the distinctive institutional ideological default was twofold: classical liberalism. Markets are pre-political realms of natural liberty, one, plus left to themselves, they will produce liberty and prosperity. Therefore, equals three, laissez-faire, right? That's the dominant default ideological, political policy, legal view. 1930s to 1970s. No. One, markets are at least in part legal constructs. Two, left to themselves, markets will often, A, fail to be competitive, monopoly, B, even when competitive, produce market failures that fail to provide social welfare. right? This is a very cramped economic critique, but that's the dominant mode. So equals 3. When markets fail, we should intervene to produce optimal social welfare, right? That's the dominant mode of thinking from the 1930s and 1970s, the market failure paradigm of welfare liberals. And then what happens? In the 1980s, the neoliberal critique, which was intellectually laid the foundations of, basically we can just identify with 2 things. Hayek in 1945 and Coase in 1960, and they consolidated a new paradigm. First, yeah, fine, markets are partly institutionally created, but they are realms of decentralized initiative and liberty. They're realms of quasi-spontaneous order that, too, don't fail nearly as often as you think. That guy up there, Robert Bork, is the main architect of that idea, right? They don't fail to be competitive nearly as often as you think, right? That's Bork's whole argument in antitrust. What you call a market failure is just a temporary winner who's soon enough going to be overcome by gales of creative destruction. All you're doing, you morons, is punishing winners, and you're not protecting competition, you're protecting losing competitors, right? These moves by Bork swept the field. Now, these are just Hayekian, Coasean moves that he did. And so the neoliberal view was markets don't fail to be competitive nearly as often as you think. And other market failures, Coase taught us, aren't really market failures. They're just failures of markets to form. And 3, any case, the government solution is often going to be worse than the market problem. So what do? Enforce some minimal ground rules for markets to exist. That's why it's not classical liberalism, it's neoliberalism. But otherwise, hands off. And preferably privatize the state as much as you can. I can't get into that part, right? But that was a frame. And that was a frame, and that frame and its effects sweeps the field. Tort law, property law, contract law, antitrust law, intellectual property. In each area, you can see it like clockwork. And so these are the sort of 3 constellations. And so what does that mean in tort law in particular? I'll wrap up by saying just a few things. 1, you can understand the period of tort law in the last 2 periods very clearly just by reading the American Restatement on Torts. So from the 1930s to the 1970s, in the area of the law of risks emerged a fundamental new regime called enterprise liability or products liability. Strict liability for risks created by firms making products. Even if they weren't negligent, they can be liable if the product is defective, right? This whole regime, partly the handiwork of one justice, Roger Traynor in California, became the dominant mode of regulating products. And then what happened? In the 1980s, the 3rd restatement draft, which was, being drafted and has now basically been adopted, calls off products liability, guts it, collapses it back into negligence after decades of the neoliberal critique. That's one area. Then the other area, not the law of accidents, but the law of civil wrongs. How you protect personal interest in security versus personal interest in liberty, and how you weigh these. In this area too, a fundamental sea change happened in the 60s as a result of the civil rights movement, the feminist movement, the women's movement, and disability rights movement. All these areas fundamentally did 2 things which reshaped the architectonic of this area of law. 1, a massive expansion of security interests from those just having to do with physical harm to those having to do with bodily indignities and invasions to those having to do with psychological harms of various sorts. All of this was learning from feminist and race-based civil rights critiques and is crystallized in a single tort, which was created again by Roger Traynor in 1965. Intentional infliction of emotional distress. The idea that you could sue someone without any physical harm was a revolution. Now, of course, there were not physical torts before, defamation, but that was about it. So this was a fundamental transformation in how tort law conceptualized interests and harms. understanding them much more sophisticatedly than in a kind of simple model of physical invasion. And secondly, and this I don't have time to get into very much, the whole way civil rights law rewrote the public-private distinction in American life. The way in which what was thought to be a private sphere, like your business, became quasi-public, because even if you're allowed to be racist in your home with respect to who you invite for the neighborhood block party, you're not allowed to do that with respect to your Sears department store lunch counter. Why? Because once you operate a business, you are quasi-public, and the interests of others in equal dignity and standing in places of public commerce trumps your interest in private association. Right? This fundamental move has its roots in the civil rights revolution, but also in private law, thinking about these questions in torts and property. There's a famous case, Shelley v. Kramer, where this whole legal realist social relations view first got articulated and then got generalized in the civil rights revolution. So, and of course, what happens in these areas? Again, the neoliberal pushback in the 80s tries to shrink and cabin and put IIED in its place and revives, of course, as we all know recently, arguments from religious conscience, freedom of association, free expression as a pushback against public accommodation by businesses on grounds of race, gender, sexuality, disability, and so forth. So this historical sweep is fundamental to understand two things. One, the law is going to always be changing. It's fluid, dynamic, it's not fixed. And two, it's helpful to understand what were the lessons of previous periods. So I'll sort of stop by just saying a couple of words on that. In American tort law, there's a kind of Mount Rushmore of judges who are in a kind of dialectic of conservative, liberal. One spawns the other. So the original judge is Oliver Wendell Holmes, a conservative in tort law. He spawns his liberal twin, Benjamin Cardozo, who in turn spawns his conservative twin, or son or whatever, Learned Hand, who in turn spawns the liberal Roger Traynor, who in turn spawns a conservative Richard Posner, who in turn spawns a liberal Guido Calabresi. And so you can basically understand all of American tort law through these six judges and their debates with each other, liberal and conservative. And that debate happens both within tort law and also about tort law vis-a-vis alternatives. And so that's the last sort of point I want to make, which is that the way tort law deals with the social questions of risk is, of course, dealt with in many other countries, not through private litigation. It's dealt with through comprehensive social insurance programs, comprehensive social regulation of risk. In the United States, for reasons we all understand, but I'll go ahead and discuss them, those programs are much more modest, narrow, rarely existing. And as a result, a lot of what happens in other countries as a matter of social regulation and compensation for risk is done in a private litigation system. That's why tort law and tort doctrine in the United States is much more overdeveloped in these areas than in really any other area, any other countries. And the important point to understand when we learn tort law is not to become wedded to the fact that tort law is the way we achieve these things. It's to understand the lessons we can learn from tort law, which we can then also apply in other areas like administration. And so, then I'll stop here. The fundamental sort of story of regulation in the United States in the 20th century has been a kind of dialectic or back and forth between two ideas. One is a Weberian idea that there are real benefits to having streamlined, coordinated administrative resolution of social policy problems. The other is the Hayekian approach, that there's a real benefit to having a decentralized, common law-based approach to dealing with social policy problems. The decentralized common law approach is incredibly costly, cumbersome, and effective leakage. But it has, and as a result, it gives rise to the idea, well, we should take it out of the common law and do it in a more sensible way, more equitable and more sensible administrative way. All right, and that's what happened in the 1930s. A bunch of areas of previously common law resolution got taken over by the administrative regulatory state. But in no area was the common law litigation system completely snuffed out. It remained as a safety valve to check the excesses and errors of the administrative capacities of these agencies. And this sort of dialectic happens throughout this period. And then as we see more and more deregulation, right, in the coming period, the fundamental battle line here will be, of course, over the legitimacy of administrative law. As we see more and more efforts to deregulate and delegitimize the administrative state, we're going to see a lot more pressure on common law litigation to sort of come in and fill in the gaps. And so the basic point I want to sort of say is, everything we've learned in one or the other of these areas is transferable. And we should think in terms of not sort of fetishizing the existing social institutional arrangements that deal with these problems, but think of new creative ways that we might want to learn from the benefits of the various approaches in the past and to recombine them in more plausible ways going forward. Okay, I think that's probably enough. And I will stop. I think that was 30 minutes on notes. All right, awesome. Okay, so how are we? Oh, I just any what PE or okay, all right. I won't say any more people that have gone minutes last.
Great. So think about your questions. I'm going to start us off with one.
Okay.
So conventional way to teach this subject would be a bunch of cases, right? And I wonder, and hard to kind of bring this down to a slightly, more tractable, like less abstract level. Like, is that how you teach torts? Do you teach it through cases in a conventional model? And is that the right way to teach torts? And do you do the thing that people in torts do? Like, here's the way efficiency would resolve. Here's the case. Here's the way efficiency would resolve that case. And here's the way a social justice approach would resolve that case. And let's talk about the different ways of proceeding and so on and so forth. Or do you think that's the wrong way to teach torts? And it's sort of nested within that question. It's a question I get a lot from students when we talk about some of the bad problems with efficiency analysis. This is kind of neoliberal approach, which is, well, at least it's a method. Do we need a method? Can you have something simple that also kind of spits out an answer in all kinds of cases? Which was potentially one of the things that makes this approach so viral. And not that there's an answer, and we can get into that. But so first, I talked a little bit about how you teach it, and do you want to play out for us? Let's play out on this case. Let's see what how you might embed this into a conversation about a case. And second, reflecting on that and how we should think about the claim that that's how one ought to go about analyzing law and teaching law and sort of thinking about it.
Okay, thanks. That's terrific. And I that exactly is where I want to go. So on the first question, I'll be honest. I teach tort law as mainly about deprogramming and reprogramming how everyone thinks about law in the class, right? It's all about law. It's just about understanding that all the magic words that people use as a way of never making mental contact with the genuine question at hand have to be stopped. So a lot of my class is just about getting people to understand that when the tort of battery says there has to be harmful contact, that doesn't mean anything, because you don't know what contact means. Because if you pull a chair and someone falls and you did it purposely and they break their hip, you didn't touch them, but you still batter them, because it doesn't matter. And so a fundamental point is just a deep method point about getting people to remove the layers of verbal noise between the genuine stakes of the case and the doctrinal mumbo jumbo in which judges hide from themselves and their audience what is really going on. And then, of course, you have to translate the conceptually clearer way of thinking about these competing interests and social policy questions back into the legal mumbo jumbo. So that's the reprogramming part. But so a lot of what I do is using cases to get people to understand the underlying social policy, social justice, social relational questions, and to get them to see how over and over again, the way these questions are approached through reified legal categories prevents anyone from making mental contact with the question at hand, except, at some point 4 a.m. when they come to their decision, and then wrap it up again in this verbiage of ex post rationalization. So a lot of it is just getting people to understand that what's going on necessarily every single time in a legal case is a question of political morality within a specific institutional context, that we have to think seriously about questions of decency and fairness, and there's no alternative. Then, when we think about questions of decency and fairness, yeah, I think you're right. I mean, the fundamental point is, okay, so what do we do? What do we think is an equitable, reasonable way of setting socially acceptable risk levels and distributing the burdens and benefits from materialized risks? In tort law, that comes up in 2 basic ways. One, what is the level of reasonable care in negligence? And the dominant method is to look at something called the hand formula, where you balance the burdens of taking greater care against the probability of loss from not taking greater care, and you maximize the benefits net of costs, all valued in dollars and cents. The economic interpretation of the BPL formula is, as Hegel called Napoleon, the world spirit on horseback. It's the dominant policy in the White House since 1981 and to this day. It runs the table. Why? Because no one's come up with an alternative, exactly as Amy said. And if you haven't come up with an alternative, no amount of fancy philosophical critique can take. No amount of anything. You can't just say life is priceless and be end with it. Okay, so let me just give an example, polemical example. Professor Judge Guido Calabresi, he says, well, of course, there's an alternative to BPL, but we can't admit that. I don't think that's a very respectable, progressive, liberal position. He says, so we should hide it. We should not be express about the fact that, of course, life is not priceless. We can't shut down all the airports. We have to build bridges and tunnels. Everything carries risks. But given that there's an alternative, but we're all squeamish, we should hide from ourselves that we're doing BPL in the economic way. I'm not sure that's a very progressive position. Seems to me a much more plausible position. If we'll get it on the table, how should we do BPL in a non-economic way? That we have to do BPL, I think is non-negotiable.
See what BPL is?
The hand formula. You weigh the burdens of taking more precautions against the probability of losses from not taking those precautions, right? The economic interpretation says you weigh all of these things by translating all the metrics into dollars and cents. Now, the first move is to show that in fact, in policy and law, no one does that. You can't translate BPL into an economic formula because there's many different ways to do the economics, none of which have a good argument over the others, and all of which, even if one of them was best, are just not plausible as a normative matter. And you got to make those arguments. BPL, from an economic point of view, is an entirely untenable, absurd position. But unless you can come up with some tractable, institutionally operationalizable alternatives, it's going to be hard to dislodge it. So it's in the saddle, even though besides a few diehard law and econ people, most people understand it doesn't really make any sense. And so the alternative is either to do it, but be squeamish and hide it, or make hand-waving appeals to community expectations. And that's the dominant alternative. I don't think that's plausible. And I think what we have to do is systematically think about different types of human interests, life and limb versus other interests, and try to figure out some way of doing a qualitatively sensitive, but institutionally operationalizable way of fairly distributing benefits and burdens across persons. It's not easy, but I think that's a lot of what our tort class is about. It's about asking those questions. And so, yeah, that's what I do. I don't give much time to the corrective justice view because I think it's so wholly implausible that I can't really. After the first 2 weeks, I hope everyone's been disabused of the idea that you can answer questions of social policy by asking what was the status quo before these 2 people ever met each other. Let's restore one to the other and not worry about anything else. That just seems like a weirdo thing to think about. So that's sort of a brief answer. Oh, sorry, Amy.
Hi, I'm Chloe. Thank you for speaking here for the semester. And I feel like I have a lot of questions, but I'll just ask one, which is we recently read Cat Code Writing, which is the case.
Yes.
Yes, about so for those who haven't read it, it's basically there's a family, they live on an abandoned, or like they have this huge property, lots of it, of the property is abandoned, and someone breaks in, like steal, or like over the course of 10 years, someone comes in, like steals stuff from their property, so they set up like a gun, which would basically shoot someone like in the bottom of the leg who's breaking in, someone breaks in, they get shot, they get injured, they sue. And the idea there is so that the court holds that, you know, that is like not okay, basically, like there is, you know, there's obviously intent to injure there, like, you know, whatever, they are liable. Sorry, yeah, obviously, but, just for the group, but, okay, but so then the question there is, I feel like then we started getting into this question of cosmetic analysis. So the idea being that in tort law, like life is valued over everything else. Like there is no situation in which property can be valued over life.
Yeah.
For the turning point of this case, because they're protecting their property, but at the expense of someone's life. But then, right, in kind of this general, like, yeah, how the world works is corporations make these decisions all the time, right? Like we're not going to choose like the safest option, which will preserve everyone's life because it's too expensive. And so like, it's not actually true that like the law values life over everything. And so, but like people seem basically okay with sort of the way that I'm not really sure how to then like approach the question of like, how can we make the law actually value life in like the way it maybe should be like over everything, or is that something viable? Or like, how would you basically respond to the question of, you know, why is it that we say, you know, tort law values life over everything, but in reality, that's not true. And how can we basically maybe change that, or should we change that? Yeah.
Brilliant, perfect. Let me just try to answer it as briefly as I can. The Caco case is a perfect illustration, right? Because from the 1930s to the 1970s, the way American law redrew the boundary between interest of property and interest in human life was fundamentally redrawn in favor of human life over property. And this is the high watermark. And since the 80s, it's been redrawn in the other direction, by and large. Pushed back, a pendulum swing. But how did this line get redrawn? This is the fundamental point. This is not a sound with which any of you have a clear associated idea. You think it means the thing, but that's not what it means. Okay, and what Caco does is it de-reifies this thing. I won't even make the sound because it'll already lobotomize the mind. And says, listen, this is a social relation dealing with competing interests. And in feudal society, it was really helpful to use a singular umbrella term, property, so that everyone could identify the baron's interest with their own interest in their home, right? The function of property as a reified lobotomized term is to invite you to confuse your interest in your personal item and your car and your home with someone else's interest in a business, and these are all the same. They're all one thing. What Caco says is no, they're not. Because the spring gun was set up to protect mason jars from being stolen by people rummaging around. And so what happened is Caco says, there's your interest in your home. There's your interest in your land when you're not living here. And then there's your interest in your mason jars. And this loses to other people's interest in life and limb. This loses to other people's interest in life and limb. This trumps other people's interest in life and limb. So you can still take out a gun and shoot someone in your home, right? So that's what happened. Now, what is going on here? There's a conceptual move of taking apart this category, which is a lobotomification. This is not a sound you can make with a clear mental idea. I guarantee it. It will never happen. Every time you use it, it's like this word. There's another lobotomification. This is a way of closing down thought in law. These things have no associated ideas. So what Caco does is break this down into this and then set up a different schedule. And it does that, but in civil wrongs. Then we go to the law of risks. And we turn it, well, wait a second, we just learned that this stuff loses to life and limb. It does. Now, in most American states, in the law of trespass and self-defense to protect your land, you can only do intentional battery to protect your home, not your land. Now, in this area, but then when you go and you find out, oh, wait a second, GF does it all the time. Shit, what's going on? Because then the second conceptual point, once you break down this categorical way of thinking, which is the 19th century way of disposing of social questions, you have some you have a category, you look inside it, like it's something in the sky, and you divine the answer by squinting, right? That's the dominant mode. That's philosophers still think is a useful way of thinking from Plato. You know, what's the essence of the category property? And they squint around for a while. And then they ask what the Latin roots are. It's all nonsense. This 19th century way of thinking gave way in the 1930s to 70s to a weighing of discrete sets of interests qualitatively identified as different schedules. But that mode of legal analysis became discredited as ad hoc, inconsistent, and got replaced by an alternative post-categorical mode. Not balancing, but, balancing on a single scale. What's the scale? Money. And once you do that, you've replaced the 19th century Platonic essentialist categorical thinking with the modern replacement of the abstract universal exchange equivalent. And that provides a way of weighing all these interests back into one flat scale. So what has to be done? We have to find ways of protecting these interests institutionally and qualitatively from being run roughshod by money. And that requires coming up with, in law and policy, ways of thinking about protecting human interests that are not reducible to maximization of dollars and cents aggregated across everyone. That's a deep question of normative thinking developed primarily by people working in the footsteps of Marx and John Stuart Mill, and developed in the 20th century by Martha Nussbaum, Amartya Sen, John Rawls. But none of that stuff has ever made a dent in the legal law and policy, because that's abstract normative thinking. And here, people dispose of concrete policy stakes, and then never the two shall meet. But you've got to find some way of translating non-monetizable values into legal institutional policies. And I think that's where it has come. And your question is exactly that question. Right? That's what happened in American law, every field. Categorical thinking, ad hoc weighing, replaced by single scale balancing. Okay.
So the ALI is right now thinking about how to approach medical monitoring. And the ALI is thinking about medical monitoring damages right now. How that fits into one thing, it seems like getting rid of the traditional requirement of a current physical injury seems like it's thinking about harm and risk in sort of a broader sense. But on the other hand, it's really just privileging this narrow view of harm as requiring a physical injury. We saw there was a court case where they were rejecting social media content monitors claim PTSD and psychological injury monitoring. And it seems like courts are still very, very married to this idea. You might not have a physical injury now, but it still has to be a physical injury. So I'm just sort of curious how we understand that fit into your idea of what we understand tort law to be doing, and how that fits into your kind of story of risk over time.
That's such a sophisticated way of understanding what's going on with medical monitoring. It's exactly right. So, right, the other fundamental story in American tort law is the story you just talked about. It's the progressive dephysicalization of our understanding of human interests, right? In the 19th century, you asked any lawyer, what do you protect? Physical stuff. What's that? The only word more lobotomizing, actually, it's less lobotomizing property. Nothing can be more lobotomizing property. physical. This word has no meaning. It has no conceptual content when anyone utters it, whether in science or law. It's just a nonsense focus. This covers what? Your body, but also sexual harassment, but also stuff, all under this word physical. Why? Because it looks real, it looks hard. We can protect the real hard stuff. And you're exactly right. The whole story of the 20th century is to dephysicalize our conception of the human interest that law should protect. But that dephysicalization comes up against limits of administrability and concerns of floodgates and evidentiary problems, right? And so medical monitoring is the question. If you've been exposed to toxic substances by a defendant, but aren't yet sick, do you have to wait till you're sick to get damages, or can you start getting damages to pay for early preventive checkups at the doc? The old view was physical is as follows: you have to wait, or what if you have a physical symptom? Then you can get it. What's a physical symptom? Coughing wasn't enough, but barfing might be because it's liquid. I'm not joking. This is the sort of way in which courts think about things. If it's coughing, it's air. If it's barfing, it's liquid. Liquid is more like a solid. Solid is physical. I mean, this is an embarrassing way that courts think about these things, and they have to look. You know, when you study commerce law, right? Laws going direct and indirect. It's pure bullshit. But it's everywhere. This categorical nonsense. It's infected the mind. So what does that mean? Yeah, we have to figure out how to, at the same time, give people damages who have been exposed to potential bodily injury, without then reinforcing the reification of human interest that involves, exactly as you're saying, which requires, there's this kind of weird dialectic, whereas, you know, if we allow that, but we only allow it in the context of bodily injury, this intangible or not yet realized harm, that might reinforce the idea that we can't elsewhere. So here, like everywhere, in law, in my view, there's a double operation that needs to be done. First, you just have to, at the conceptual level, de-reify how people are thinking about the policy problem. That's a big obstacle in law. But that doesn't address the whole problem. Because second, there are genuine issues of administrability, of evidence, right? And so then you've got to figure out, once you fully de-reify, de-physicalize someone's consciousness, then you still got to tackle the problems, right? The conceptual move is a critique, it's a negative move to eliminate false ways of solving problems. Then the real way of solving it still has to begin. So I'm sorry, I can't say any more than that, but it's really terrific. Sorry, there's someone here in the name, yeah, I don't know.
No, we have a question from the chat.
Okay.
Yeah, I was wondering where you situate contemporary civil recourse theory within your scheme. Because
Contemporary what?
Civil recourse theory, like contemporary, where do you situate that? Because it doesn't seem like social policy. It need not be doing corrective justice in the sense of assuming a naturalized baseline or any baseline at all, really. It need not be implementing some sort of neoliberal agenda. So I'm just wondering where you sit that within the scheme, and also whether you think that it provides like flexibility and is helpful kind of evaluative and qualitative analysis of taking into your own interests that we need to take into account.
Wonderful. So unfortunately, unlike others, I'm not a great diplomat about these things. So I'm just going to tell you what I think, which is that I think civil recourse theory is nothing more or less than a retrograde attempt at winding the clock back to the 19th century with a minimal patina of post-realist sophistication. So to justify that, let me say a couple of things, right? So first of all, civil recourse theory is a development in the late 90s and later on, which echoes another development that happened at the same time, both of which are neoliberal articulations in private law of a revolt against the 30s and 70s, okay? Law and economics and civil recourse theory are just like basically evil twins. They think they're really competitive, but they have the exact same view on every question, except they have a different gloss on how to get there. So what do I mean? Well, in civil recourse theory, you read, what do they think you should get for pain and suffering damages? Well, they think, of course, the economic view is so good. Then what? Nothing. Or symbolic. They have no way of qualitatively changing the analysis. You say they don't have to be corrective justice. Yeah, they don't say that because corrective justice was destroyed by Coase. And they realize that they can't go back, right? Neoliberalism is not classical liberalism. They're the neo. The neo is always responding to the 30s, 70s critique to defang it so we can return safely to the 70s, 30s era in a more sophisticated way. In every single field, the exact same structure replaces itself. And so here, civil recourse theory is nothing more or less than you read the main symposium, the new private law theory. What do they say? This is really an area of private law, and by that we mean, and then they don't tell you. They say, yeah, we know legal realism, the state enforces the rules, but nevertheless, these are different. They're not public, they're private. What is that? That's another way attempt to what? Defang the social relational insight of any significance and privatize and individualize and bilateralize the question of justice. And that's the whole ballgame. That's the whole ballgame. All of these people, everyone who touches law with a philosopher's tool, never has advanced half an inch beyond the pre-Rawlsian state of philosophy. Okay, Rawls said, look, all these questions of justice are questions of social justice dealing with the social structure. I've read Marx, I've read Weber. No other philosophers seem to have. So, sorry, but that's what I think of civil recourse theory. It's absolutely a neoliberal move. No matter what they say, it's conceptually and structurally on all fours.
Can I?
Yes.
So here's a question from the chat. Can you speak to or historicize the way tort law has been used in the US over time, successfully or not, to try and apply standards of international law in domestic courts? I'm thinking specifically of the Alien Tort Statute in its initial applications in the 1780s versus applications against corporate defendants pre and post Kiobel versus Royal Dutch. I'm interested in understanding why these questions of social relations and risk between corporate subjects, foreign plaintiffs, seem to have been filtered just through tort law instead of other areas like criminal law.
Okay, so I honestly can't speak to that with any degree of real knowledge or expertise. So all I can say are very broad brush ideas, and I apologize for this. Both the historical and the criminal, all I can say is broad brush ideas. In my understanding, there was an effervescence of these tort claims, which has now been basically closed by a bunch of doctrinal moves, which make these claims much less available in the last 3 decades, which reflects very much the periodization. Now, why does this happen in tort law rather than criminal law? I think the answer is relatively clear, but maybe not, which is that, it doesn't involve the same stakes of extraterritorial jurisdictional reach that crim law might. And there's a general point there about tort law that question raises. Tort law is probably the most ripe area of law to try to take over and develop various questions of social policy, because it's the most open-ended. It doesn't require prior contract. It doesn't involve putting anyone in incarceration, and it doesn't involve requiring any actual tangible resources or intangible resources. So, public nuisance law in tort law is the foundation of environmental regulation. And with the administrative state and the EPA being gutted, more and more climate change policy is trying to be pursued through tort law avenues again, because it's got to fill in the gap. But I can't speak more to the Alien Torts Claim Act than that. Any other questions, comments, pushbacks? These pushbacks would be great. I mean, I love this. So, by the way, you're more than welcome to tell me I'm wrong. I love it.
Thank you so much for the fascinating presentation. So you're doing you're distinguishing 3 periods of the recent history of American law, and you said that they were defaults in each of them, and I was wondering which defaults to identify more precisely in the 13-18 period, and is it because it was still the market which was in the middle of the understanding of law?
So which default in 30s and 70s period, and then what was the next one? No, but you were saying you were having.
Is it because we are still seeing the market as the first institution that we should think of, but
In the 30s and 70s?
Yeah.
Yeah, so, I don't know if this lands, in the 30s and 70s, what happened? the default became markets are neither natural but socially constructed. Second, if you leave them alone, they often produce bad outcomes. So we can't leave them alone, we must regulate, right? Those are the two defaults. So you have to regulate markets, but for what? To solve market failures, to produce social welfare. And the idea of market failure and social welfare as a solution already presupposed economic thinking in the saddle. So it was pretty short in time and pretty easy in doing to dislodge that by using the same tools in the neoliberal way. So I think that going forward, we have to think about the problems with markets as not simply being market failures to be efficient, and the solutions not being simply balancing on a single scale utility and then social welfare. That's how I understand it going forward, but I don't think that's responsive to what you're asking. Okay, perfect.
So I have some 2 or 3 questions which are not very clear, so you'll help me asking the questions. So the first one is, so I understand there are limits thinking about the market in terms of problems that need to be corrected, either through regulation or compensation for the market. So therefore,
Regulation or what?
compensation, right? So that's not at all. But then I keep trying to understand whether your way of thinking or law included before you would be able to theorize about ways to reconstruct the institutions of the market. Or to which extent the way this reconstructive approach could also open a gateway for the reconstructive process. That's the first question. The second question is, if I understand correctly, I think for a couple of years, Duncan Kennedy and others, they suggested that this contemporary moment of mobilization would be perceived as a moment of pluralism or diversification of methods and approaches to law. So what I mean by the law and political economy approach is that actually this diversification is actually the periphery of a centralized dominant approach, which is based on this community of the market and its authority in our way of thinking. Is that it? So if it is your approach different from this approach that I understand well, that's the approach that actually Duncan has taken over the years. These are the 2 questions.
So wonderful questions, thank you. So the first one, institutional reconstruction. I think there's a fundamental question within LPE that has to be hashed out. One view says the market is an endlessly indeterminate institution, and our task is to reconstruct the market. That's important. I don't doubt that that's important. Another view says, no. There are certain specifiable tendencies and features of markets, and our task is not just to, and so the first view says, we're not just interested in regulating the market. We want to restructure the market, right? That's one view. Restructure antitrust law, not just regulate. That's an important LPE view. It's not regulation, it's more. Another view says, look, that's important, but we don't just want to reconstruct the market. We also want to put the market in its place. We want to embed the market. We want to reduce market dependence as the operative dynamic of a capitalist society. We want to reduce the extent to which everyone is subject to the ceaseless logic of expanding exchange value as a result of everyone having to subject themselves to market imperatives. We want to increase freedom from in the market by increasing freedom from the market, by allowing more and more of human interest to be realized outside of the market metric. So embedding the market is different than restructuring the market, right? So restructuring the market accepts the market as the institutional domain and then tries to tweak rules internal to it that will produce better outcomes. And I think that's important. But another approach is, no. Some stuff must be removed from the market. Like when the FDA regulates drug safety and efficacy, its yardsticks of safety and efficacy should not implicitly use that. If that's what you're doing, you're just reproducing, mimicking the market. So that's one big question. The reconstructive question, there's 2 issues, not just regulate, but restructure, and not just restructure, but embed. And so that's one. Second, if I've understood, you're asking about Duncan Kennedy's 3 globalization periodization, right? So the periodization I laid out is fundamentally at odds with Duncan Kennedy's periodization. Duncan Kennedy's periodization is 1945 to 2000. Mine is no, that's not a period. One period is 1930s to 1970s, another period is 1980s to 2016. And that matters. Why? Because I think these periods are discontinuous in their default institutional ideological frameworks and assumptions, and really have different regimes. Kennedy's period is just a large period, and then when you ask them what period, what's in this period, there's a whole laundry list of a chart of different things, and we ask them what do these things mean? Well, I don't know. They're like the langue in which people do the whole of legal argument. And when you ask what does that mean, not much more. I'm not making a weak claim. I'm making a very strong claim that there are institutional and discursive or ideological defaults which frame and shape thinking in law and policy across different fields, which are continuous and united in these two periods. And they are very different from each other. And so, yeah, I'm saying that's exactly what's happening, that from the 70s to today, the neoliberal period became ascendant and hegemonic in the United States and many other parts of the world. And you can see that, for example, in how European competition law changed in this period from its old ideas to those of purely Chicago school. And you can see that in a ton of areas everywhere. Does that answer the question? Perfect.
So I previously worked at the CFPB. We did a regulation, or we adjusted a regulation towards the cost benefit analysis. So I'm not sure if that's equivalent to a BPL, as you were saying.
Yeah.
And in addition to that, we had a dual mandate, of course, like enhancing market access, greater transparency, and those things. So it seems like maybe a cost benefit analysis plus, or like a BPL plus. If you have any thoughts on that, or if there are other considerations when doing these things, the appropriate that could get us past the single scale. I'd love to hear.
Wonderful. So I'm a big fan of both, right? So the first thing you're saying, cost benefit plus, say, expanded rural access. That in itself is an overturning of neoliberal thinking, right? Because in neoliberal thinking, any plus you do the cost benefit analysis is called an ex post redistribution. And it should be done one time through tax and transfer, right? The idea that you should do field specific considerations of distribution and access, like in a regulated utility context, is anathema to the neoliberal view, right? The neoliberal view says, listen, for all of policy, there's one tool, cost benefit analysis and efficiency terms. Then if you don't like that from a distributed point of view, take it up with the tax system. So the idea that you can do field specific equitable considerations is itself a big departure. One. Second, I also think in certain contexts, you must go beyond equitable corrections to efficiency. In certain contexts, you have to make substantive judgments about the good beyond just fair distribution. And that's something that goes beyond not just neoliberalism, but liberalism, classical neo-welfarist. All these three periods are united by liberalism. But once you make substantive judgments of social good, social policy, that's beyond liberalism. And that's something that scares many people. But I think LPE should be open to the idea that democratic agency requires making these sorts of social judgments in certain contexts. I don't know if that answers that. That's great. Very nice. I'm happy to keep going. Oh, sure, go.
Yeah, I just want to kind of quick follow up to that, which is that seems like we've kind of bracketed the question of whether to have a tort system versus whether to have some other way. Risk or more robust welfare state, administrative procedures, because in either case, we're going to be thinking about social justice. But it seems like the actor that's being asked to make these judgments of distribution of value is different in different cases. And so I'm curious, thinking through kind of tort law from an LPE frame, do we need to have an orientation towards, whether judges to make these value assessments versus whether like we need to scrap the project of tort law entirely on democratic grounds?
Okay, well, that's brilliant. And you're asking the $1 trillion, look at me, I can't even help myself, question. It's huge. Look, I can only say a couple of things. First, I understand where the question comes from. I'm very sympathetic to the idea. I think it's very important. both on instrumental and intrinsic grounds. Instrumentally, I think administration can be often much more effective than decentralized common law litigation. And intrinsically, it can be a better locus of democratic agency than the courts. So I agree with all that. Having said that, the fundamental question facing, well, there's many fundamental questions. One fundamental question facing democratic equality is the following. Society is politically constituted on an ongoing iterative basis. We constantly, iteratively, politically constitute the social relations that are society. And it is implausible that the good people of Vermont meet every day to do that. We need to find ways of understanding how to decentralize, in a decentralized way, carry out the political reconstitution of society. I consider that the single biggest, deepest, hardest theoretical question we face. So that's all I can say about it. That's pretty good.
If someone else wants to ask a question. So I was wondering, or I think I followed kind of this point about the restructuring of the market versus the embedding of the market. And I'm wondering then kind of like maybe in practical terms, how that would look. So I think kind of to the truth, like the GM example that you were giving, I think you said that GM should, or we should also think of other ways to essentially value life other than money. And so like that seems simple in theory, but I don't know exactly how we would do that. Obviously, the market has colonized my mind too, but like I'm wondering how, or like what are certain criteria that you might use to.
That's true. So I'm going to say two things. One, which is going to not answer the question, but hopefully buy me some time. Two, something that'll try to answer the question. Right. The first point is about embedding. Like just to give it like the call it, right? One way to deal with access to healthcare is what private insurance. That's just a completely deregulated, everyone for themselves market solution. Right? What's another way? Employer-based insurance. That's still a market-based solution, right? Tying healthcare to the job and et cetera, et cetera. Then what's the third? Employer-based insurance plus needs-based Medicare and Medicaid for certain subsets of the population, right? That's still a kind of more distributed, but somewhat still market-based approach, the classic needs-based. And then, of course, we have the fourth, right? Universal commitment to equitable access to healthcare for all, Medicare for all. Healthcare is a human right, which means for me, it's to be decommodified, not the market, right? So we can understand all these different options, but I think Medicare for all is basically embedding the market, right? There'll still be markets for the provision of healthcare services, but the payment of services and the channeling of incentives will now be done in a very different way as a result of how we are paying for it than in the other three options, which are all still much more market driven and regulated or unregulated. So that's just a sense of the spectrum, right? And in any area of policy, you can sort of see these spectrums. So now on your first second point. Okay, so I don't want to get too deep into it, but look, I mean, there are two different approaches to answer your question within specific contexts like the FDA. Okay. One is that you set a qualitative category schedules of different safety harms of different drugs. And then say, these types of harms can't be balanced against these types of very modest benefits. Because if you allow these two to be weighed, then very trivial benefits over a large number will always swamp extreme harms to a few, right? That's just inherent to the market metric, right? And so you, as you said, our mind's been taken over by markets. And that's a very deep and important point. Right? Many people think this is an ideology of economic analysis and utilitarianism. No. Utilitarianism and economic analysis are the reflection in consciousness of the spontaneous thinking patterns that market societies generate. They're just ideology in the classic sense. There's nothing more perfect as an illustration of Gramscian common sense than utilitarianism. The idea that utilitarianism is some sort of first principles philosophy is just laughable. It's nothing more than the reflection in a human mind of what the market is. The idea that you can sum up all benefits and costs across human beings and then quantify them and then maximize. I mean, that just makes no sense from a normative point of view. Ask anyone. The defeat of utilitarianism happens every decade in philosophy. It doesn't matter. It still runs the show because it reflects the market consciousness and practice. So one way to do it is to qualitatively break up the quantitative interest and then not allow certain waves happening across different schedules. Another way, my cop-out way, and that I'm pursuing in my work on safety regulation, is simply to say, before you aggregate different interests, you have to apply a non-linear function so that very important interests are disproportionately protected against lesser interests, not linearly. It's a very technical argument. And the basic point is to break up the quantification that market consciousness imposes as a real abstraction on people by suggesting that you have to qualify the way. But all of this, by the way, refuses a retreat back to the 19th century so-called deontological way of categorically protecting interests in an absolute way. I don't think there's any way to go back to that. We have to understand that human society involves difficult judgments across human lives, and that means weighing. But I don't think weighing has to be single scale balancing. So all I can say is, you know, give me your email and I'll send you my draft where I propose how to do this. Oh, there's one here and then one back there.
Oh, I was just gonna follow up on that and say, I think you could connect to conversations that you were just having and say, there's another thing to put on the table there, which is democratic values, right? And so the FDA does in fact have processes that invite the public in. And so one of the, as you say, like the big question we ought to be asking, you know, if democratic values are a place that we ought in fact to invest some of our moral concern, because this is where we actually stand all as equals, that being one of the definitions of democracy. Then we have to think about how do you bring democracy into these decisions and not get to some technically or philosophically right answer only, although there's always going to be some sort of complicated back and forth between those that form of like sort of moral thinking and democratic, what we even define as democratic, right? But that there also has to be an element that's about determining who's involved in making that decision. And determining it not in a sort of you know, silly old-fashioned way, but then here also bringing back questions about who tends to be well represented in institutions of government in making decisions and who is not. And to some degree, the FDA, the farthest they've gotten is disease groups come in and can present to us and have an official role, for example. That's not very far, right? There are a lot of other ways to think about what it might mean to sort of try to democratize these sort of administrative processes that are going to be essential if you're thinking about managing at a bureaucratic level, really decisions about managing the economy, also healthcare and so forth. But I do think that's another way, like pulling those two things together seems
I think that's
like
great.
an important, interesting direction to go.
Fundamental. That was awesome. Thank you. Yeah.
Contractarian theory has cabined a lot of
Sorry?
contractarian theory has cabined a lot of international controversies and various arbitration regimes like WTO. So I guess my question is can your framework be expanded beyond borders, perhaps by throwing up like the nation on like the de-reification list? Especially, we just had the Anderson conference, and one of the last questions was by a Pakistani judge talking about like international torts as really a solution, but or I guess as a solution to the climate crisis, like how it is. And one of the answers was kind of just create one more international court with more.
So I think I followed, but I didn't understand the opening part. Contractarian, what? I didn't understand. What did you say? Contractarian?
Yeah.
I don't, what do you mean by that? In this
Well,
context?
everyone's signatory of the WTO, which means that any controversies go through their arbitration process.
Oh, I see. Okay, well, yeah, no, that's well, yeah, that's just wonderful what you're saying now. I mean, that's exactly right. At the domestic level, the simplest way to understand tort law is that it's a way of embedding contract law, right? Embedding the market by saying, listen, this is how you got contract out. Right? Tort law has that. And when you learn the law, you learn there's all these waivers of liability, but the court keeps writing them down because they're uncomfortable with people making these deals and the fine print on the 5th page in conditions where they're not reflected. So yeah, it's absolutely the case that tort law represents an embedding of the contract regime for the sake of pursuing values outside of those that the parties in transactional settings will agree to. And so that's the most controversial feature of tort law, that it does that. that it insists that there's another way of disposing questions besides those of the market. Juries as citizens, participants in FTA processes as citizens, and so forth. Your further question is how this model may or may not be internationalized, right? Look, that's just, I mean, I don't have anything particularly interesting to say on that, except I think it's a fundamental question. I don't understand my commitments to be at all nationally bound. I think we fundamentally always historically have to understand the extent to which this country has been implicated and implicating the fates of others. And at this point, it seems to me irrefutable that climate policy is fundamentally a question of justice between peoples. And so that's completely right. And I think there's no way to defer to a contractarian regime like the WTO, where bargaining power plays such a big role in disposing of the stakes. Now, what does that mean institutionally and policy-wise? It's not my area, so I don't know much. But basically, I'm very skeptical of the skeptics in America, like Cass Sunstein, that climate change involves questions of cross-national equity, right? There's many American scholars who don't know, but I think that's crazy. Of course it has to. It's absurd for countries that have contributed the lion's share of the problem to now turn around and tell countries who are at lower levels of standard development that they should bear the burden in an equal way in a formal sense. That just makes no sense as a matter of equity. So that's all I can say. I'm very satisfied. So.
Great.
Okay.
We've reached 1:30, so I think it's okay. I think Talha, you can probably stay for a few moments and talk, but I think we should just join me in thanking Talha.
Thank you.